Welcome to Immigration Quicktake. This is Duygu Erçman with the American Immigration Lawyers Association. In the past 24 hours, both USCIS and ICE issued memos on handling of asylum and refugee claims in accordance with Attorney General Jeff Sessions' decision last month in the matter of AB. AILA's Director of Government Relations, Chen, is here to discuss the significance of these documents. Thanks for joining us, Greg. What do these memos say about gang and domestic violence-related claims?
Well, these two new memoranda, when read together with the AG's recent decision in the matter of AB, serve as an instruction to asylum officers to deny gang-related and domestic violence-based asylum claims as a matter of course and on a categorical basis, when asylum officers should really be looking at each case on a case-by-case basis. What does this mean? Well, it means that a mother who has been horribly beaten, abused by a domestic partner, and is fleeing from that violence and comes to the United States, she's going to be deported right back to that violence. Or a young person who has refused to be inducted into a gang, gets violent threats or threats against his or her family, that person is not going to have the opportunity to seek asylum here in the United States. Now, while the focus of these memoranda is on the gang-related and domestic violence claims, the fact is that the reach and impact of these memoranda is going to be far broader, and effectively we are going to see the opportunity to seek asylum being really closed off for so many people coming to our borders who are vulnerable and deserving of protection.
How will these affect the situation at the border?
So we will really see two major changes at the border. First of all, now the act of crossing the border illegally into our country when you are seeking protection, seeking asylum, that is now going to be a grounds for denying asylum. We knew that the Attorney General was moving in this direction, but now the new guidance makes it absolutely clear and instructs asylum officers and gives them the authorization to deny these claims if somebody has unlawfully entered the country. And this, as we know, violates both U.S. and international law, which guarantee asylum seekers the right to seek that protection when they come here, even if they do not cross the border at ports of entry, but do so without the proper authorization or documents. The second major change in the border region is going to be that asylum officers themselves are going to start acting more like immigration judges. And what I mean by that is the asylum officers are supposed to be conducting a preliminary screening for credible fear. That's set out in statute in Congress for the credible fear standard. And that standard is designed to make sure that asylum seekers have an opportunity to go before an asylum officer and make out a preliminary showing. And then later on, they will come before an immigration judge if they demonstrate a positive credible fear to the asylum officer. But now, under these heightened standards, asylum officers are going to be making much more rigorous determinations when they interview those asylum seekers. And how can we expect that an individual who comes here without any real knowledge of our asylum laws, may not even speak English, is going to be able to make out a complicated claim without an attorney or even the opportunity to obtain the documents or other evidence to support and corroborate that claim? It's an impossible standard that violates due process and will deny them the opportunity to come before a judge to seek that claim, because they'll be denied immediately at the time they appear before the asylum officer.
Are there actions that AILA members and the public can take?
So obviously, the most important thing that AILA members should do is to review these two memos that have come out from USCIS and ICE and evaluate the impact they will have on your clients. Then we will be posting very soon different resources that interpret the memos, and we hope they'll be a good resource for you to look at. Secondly, really starting to prepare and think through litigation strategies in situations where your clients are denied asylum, where you might be able to go into federal court. That's going to be an important another step. We know that the breadth of these new policies is going to be incredible in terms of the changes to asylum law. And one thing that we are just hoping all of our members will do is to contact your members of Congress, make sure they understand the impact here, even with so many other things going on in the immigration front. This is a gross overreach and abuse of executive authority. We need to make sure Congress understands it, that they've gone beyond what Congress said in statute, and to hold the agency accountable.
Thank you, Greg, for joining us. And all of you out there, Please stay tuned for more updates from the American Immigration Lawyers Association.